name's Robert Gilstrap, and today I'm going to be talking about the eviction process in Georgia. And of course, this varies county by county, as with most states. And so the process, the money, the time frames, everything really varies by county that the property is located in. So, but I'm going to give you a real brief generalization of the process. And it starts, of course, with a tenant not paying the rent. And when a tenant doesn't pay the rent, of course, we don't like that. And so we're going to have to notify them or demand payment, and that's step number one in the process. Step number two is to actually do the filing in the county in which the property is located, and this can either be done online or in person. Again, it varies by county. Some don't allow it to be done online and require it to be done in person. And the fees associated with that filing vary wildly. They're all over the board. It could be under $100 up to several hundred. It just depends, just for the filing fees. Then step two is they're going to have to be served with the court paperwork, and that's either done through a process server, a private process server, or a sheriff's deputy or a constable. And again, that depends as well on what county the property is located in as to what their procedure is for that, and there's a fee for that as well. And they're either going to be personally served or they're going to be what's called tack and mail, where they're not personally served, but they're notified by literally tacking it to the door and then mailing a copy of that. And then the tenant is going to have so many days to answer. Now in Georgia, after they've been quote unquote served, they have 7 days to file an answer. And the tenant's either going to file an answer or they're not going to. And if they do, then the court is going to schedule a hearing, an actual court date. If they don't, then you're going to get what's called a default judgment or a default writ, and which could be good. But let's go back to if they did. If they did file an answer, and that answer could be just about anything in the state of Georgia, then you're going to have a court date, and that's going to push it out a little bit longer. And again, that varies by county. Some counties you might have a court date in as little as 3 or 4 days from the day that they answer. Other counties, it could be a month plus, 2 months. So the time frame is vastly different depending upon where you're at. And once you, let's presume that you win in court or you get your default judgment, at either case, with those two circumstances, you're going to get what's called a writ of possession. And that sheet of paper from the judge is what is going to give you legal authority to regain or reclaim possession of your property. And that's going to be often done, depending again, but depending upon which county it is going to be processed through either a private company, or it could be done through the sheriff's department or a constable. And so that's just a brief overview of the process. Again, everything varies by county, and I'm going to do a much longer blog topic on this and go into a lot more detail. So anyway, stay tuned for that. Thanks.